Court does call the case, People versus Matthew Wright.
We are starting this docket at full speed, and right away you can feel the tension in the room. Judge Simpson isn't easing into his morning. He's diving straight into procedural decisions that can completely change the course of someone's life. The very first case, the prosecution admits they're unable to proceed at the preliminary exam. That's not a small issue. A preliminary exam is where the state must show probable cause, basically enough evidence to justify moving the case forward. When they can't even get a witness to authorize or appear, that's a serious breakdown. And what happens? Defense moves to dismiss, and the judge grants it. Just like that, the case is dismissed on the defendant's motion. That's a huge win for the defense, but it also raises questions. Why wasn't the prosecution ready? Was this poor coordination, and reluctant witnesses, or something deeper going on behind the scenes? This is the kind of morning where cases rise and fall in minutes. Some defendants walk out with charges gone. Others are just getting started. And trust me, as we move down this docket, the tone is going to shift fast. Stay with this, because what starts as routine court business is about to escalate into bond battles, violent threats, and a defendant who absolutely does not hold back.
I'm sorry? Thank you. Okay. What are we doing?
Your Honor, maybe approach me really quickly.
That's how you want to start my day?
Mm-hmm.
Fine. Fine. You're not asking. Jerry says I'm not asking. Yeah, come on. All right. Record to reflect at a bench conference.
Hey, Your Honor, this is an exact preliminary exam. I did explain to counsel that it appears we are not able to proceed at this time. We anticipate that we may be able to, once we can get a hold of the defendant witness in this matter, and we will be authorizing the case promptly as soon as we can.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is on defendant's motion. Thank you. Court does call the case, People versus Leon Booker.
Amazon on behalf of the people, Your Honor.
Oh yeah, hours ago. But don't worry about it. No, I thought you were here all day. Yes, it has, Mr. Thank you.
Your Honor, at this time, people are unable to count one. I would ask the court to remand count two to district court.
Be brandishing in public.
Correct, Your Honor.
All right. So I'll dismiss count one, maintain the plea of not guilty as to count two.
This is a textbook example of how charges can be strategically narrowed. Count one gets dismissed. That's a partial victory, but count two survives, and the plea of not guilty remains in place. When a judge dismisses one count but keeps another, it often signals that the prosecution may have overcharged initially or lacked sufficient evidence on at least one allegation. Notice the structure: dismissal, plea maintained, pretrial scheduled. This is procedural rhythm. The case isn't over, it's being reshaped. And that pretrial date, that's where negotiations often heat up. Plea deals, evidentiary challenges, maybe even motions to suppress. Here's the real question. When one charge falls early, does it weaken the prosecution's leverage moving forward, or does it simply tighten their focus on what they believe they can prove? These small procedural rulings can completely shift bargaining power behind closed doors.
This matter will be set for pretrial 1482 District Court on
April 30th at 9 a.m. before Judge Barr.
April 30th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
All right, thank you. And we'll continue. Court does call the case, People versus Dimitrios Mastapops Delapis.
Amazon on
Why are you
behalf of the
laughing?
Your Honor, Joe, on behalf of defendant, state your name.
Dimitrios Mastapostolis.
Okay, I got everything but one syllable in there. I was close. All right.
Your Honor, today's the date and time set for preliminary examination. At this time, I would ask the court to amend count 1 to make an attempt interfering with electronic communications. And then we would ask the court to remand on counts 1 through 4 to district court.
Okay, I'm not going to be able to do it that way.
After count 1.
I have to, yeah, because what has to happen is count 1 would be dismissed. And then he would go down to on counts 2, 3, 4, and 5, which would become the attempt. I'm going to need the PAC code on that one. It's likely going to be 755.45A with a bracketed A.
Correct, Your Honor.
Does anyone have any objection to that?
No, Your Honor, thank you.
What just happened here is subtle but important. The prosecution asks to amend count 1 into an attempt charge, which usually means they're stepping down from a completed offense to an attempted one. That's significant because attempt charges often carry lower penalties. Judge Simpson pushes back on procedure first. He's making sure the structure is legally clean. Count 1 gets dismissed, then restructured under a new statutory code. This is procedural precision. Judges don't allow sloppy charge conversions. Everything must align with the correct penal code section. When the judge asks for the PAC code, that's him making sure the statutory authority is correct before allowing the amendment. And when the defense says no objection, that often signals a strategic decision. Fighting it might not help. Accepting the lesser framework might. These quiet moments in court are where legal chess gets played. No yelling, no drama, just calculated positioning.
I would order that the people are to file an amended complaint in the case so that everything is clear.
We'll get that out to you.
And as to count 5, your client is standing mute to that, Judge.
Thank you, Your Honor. Yes.
And court will enter a not guilty plea. Maintain his not guilty pleas to counts 2, 3, and 4. Count 1 is dismissed. I will set a pretrial before Judge Freshour, April 24th, 2025, 10 a.m.
Your Honor, can I ask a quick question? Is that here?
Yes, it would have to be. It's here.
Right. That would be greatly preferred. It's a DV. She likes to hurry the DV docket, but this is a client who's already been to court, been admonished on his bond condition. That's what she likes to do, and I'm not criticizing that. I'm just stating it factually.
So May 6th, 10 a.m. before Judge Freshour.
Thank you.
Bond will continue. Court does call the case of the people versus Derek Graham.
And is that on behalf of the people, Your Honor?
All two. Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, as case 24 FB 1431, the people are unable to proceed as to count and as that count to be remanded to district court. And in case 25 FB 1109, people would ask the court to add a count 2 of misdemeanor stalking. The PAC code 750.411H, and we are unable to proceed as to count 1. Would ask that count 2 be remanded to district court. Your Honor.
Your Honor, with regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges count 1 in both files be dismissed.
All right. In the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed. Continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B for. Before I give you a date on that, let me.
We're going to ask the court for bond on that matter, Your Honor. So if they can just take care of the other matter, we can address both cases.
All right. And so dismiss count 1. You're adding misdemeanor stalking.
Correct, Your Honor.
And the PAC code on that.
750.411H. It's 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation.
I'm sorry, Your Honor, my client was asking me a question.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right. Count one in that case is dismissed. I'll set pretrial in these matters. All right. In both cases, pretrial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go-to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
Sorry?
Miami Avenue in Ipsy.
That would be his home address, Your Honor. I just didn't know whether the alleged victim was also at that address.
Well,
She's not.
my no go-to is for Dakota Avenue, so I don't. Is that all right? Okay. All right. So people's response.
Your Honor, we would object to any modification of, we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that aspect. But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark their ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you in broad ass daylight. So I have great concerns.
This is the emotional center of the case. When the prosecutor reads those threats into the record, the temperature in the courtroom changes. These aren't vague statements. They are specific, graphic, violent threats involving children. That immediately elevates community safety concerns. But then the defense counters. The defendant was in custody when some of these statements were made. Jail calls, emotional outbursts, anger. The defense argument is essentially, words spoken in anger aren't equivalent to imminent action. So now the judge is weighing risk versus rhetoric. The prosecution argues danger, the defense argues context, and that's what bond hearings really are. Predictive judgments. No one has been harmed, but the language is extreme. What would you prioritize here? The presumption of innocence and reduced charges, or the seriousness of the threats? This is where judicial discretion becomes everything.
Given the nature of these threats, and given that we have not had contact with the victim today, but did recently on Friday, and that she was on board, we have great concerns. But I also believe he has a hold out of Jackson County for child support as well, Your Honor.
If that's the case, I was unaware of that part. The part about Jackson, that could be addressed if he's released on bond from here. Your Honor, with regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victims a day or two before when they don't show. This is certainly not the first time that's happened. But all I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client because he's been sitting in the Washington County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And Your Honor, these threats were from the police report, not from jail calls. They were from what he sent the victim's phone that led to the charges.
So he was out. He was not in custody when he allegedly made these threats, and nothing happened to anybody. So Mr. Graham doesn't get insulted. It was running in his mouth. right?
When he's out, is he working? Or,
Well, it's kind of, he's been in custody for a while, Your Honor, I assume, so I don't know the answer to that question.
got it.
Charge set up for April 1st, and I said it on this misdemeanor. And they had that prosecutor was Woods, and it was addressed, so it should have been a problem. But I had a job, I was gonna start April 1st. No, I think they need to go to bond, but she said she wanted to see this case.
Right now, his bonds are set at $100,000 cash surety in each case. I'll reduce the defendant's bond in each of these cases, $25,000 cash surety in each case. Defendant must be placed on a tether, which is the previous order prior to any release. Now, the only I don't know. Oh, okay, they both do. The tethers, as they read, are exclusion zones around the Dakota address. So, sorry. All right. Thank you.
Right, just one moment. My client seems to think that the bonds are 50,000.
10% bid.
Did they get changed at some point?
The bonds I had originally were both 100,000 cash surety, but were not changed before
He's on
the
two felony cases.
And then he has a misdemeanor case of now he's saying that come out, we did 14 feet.
So he's
So
reducing.
that's the bond that he's referring to.
Oh,
It's 100K cash surety.
Yeah, that's right. That's what I have.
That's for the felonies.
On these two cases, I had 100,000 cash surety on each case.
Let's work. All right, Jeff.
All right. Thank you. Court, that's called the case of the People versus Haley Gregg.
If you were to look at the first people,
Courtroom, please, for Assistant Public Defender on behalf of Ms. Gregg. Ms. Gregg, will you do the podium? Please state your name for the record. Here we go. Thank you, Judge. State time set for one examination in the matter. I have spoken to Mr. Duffy, Ms. Gregg. At this time, the case has been offered to be like to wait for this time, second court to see further resolution.
Ma'am, is that correct? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right.
it's right.
Preliminary examination have been waived. Defendants bound over to circuit court on count 1 with 2 following. Mr. Fee.
Judge, we will wait for a reason to stand mute.
Defendant never waived formal reading. Standing mute to both counts. Court will enter not guilty plea. Pretrial will be set for
May 7th at 1:30 before Judge Conlon.
May 7th, 2025, 1:30 before Judge Conlon. Bond will continue.
Judge, I just want to address.
Oh, go ahead.
Thank you, Judge. My understanding, Mr. Duffy, is that Ms. Gregg does not have a full history. Obviously, this case, the allegation that Ms. Gregg is acting out of character for herself. She is ready to take responsibility and resolve this matter, hence the waiver. She is asking the right to consider the reduction of her bond and a possible release. She has no problem with the tether. She would have no problems with the tether and following our court orders. In the meanwhile, I'm going to look into possible treatment courts for Ms. Gregg. And she said that she would follow the conditions. And I believe she wants to address it. I didn't really want to talk about what happened in this case. Why did you want to talk about? I didn't have why they do like court misstep. I had other issues, but I had Chuck was told it, and my phone was in there. I you know, it's not really an excuse, but I didn't really have a way to communicate with anybody, and I was scared. I didn't know what to do. I've never been through this situation. I usually, if I get arrested, I find myself out when I come and I pay my fees. And this has been a terrifying experience. I'm not used to any of this for real. I don't know what else to say other than I'm sorry. I go on my character. I want to put medication.
So,
Yeah, I've been on my medication. I've been.
okay, let me ask you this. You failed to show, the reason she's in is because she failed to show in February. And I issued the bench warrant.
Now we pivot to Haley Gregor, and this feels completely different. This isn't threats and stalking. This is failure to appear. And that matters. When a defendant misses court, judges take it personally, not emotionally, but procedurally. Court dates are mandatory. Missing one triggers a bench warrant, and that's exactly what happened here. But listen to her explanation. Homelessness, no phone access, fear, medication issues. These are not legal defenses, but they are human context. Judges often weigh compliance history and stability. She admits she did nothing after missing court. That's not great, but she also didn't run states away. She was found locally. This is where judicial temperament comes into play. Is this defiance or instability? Is she dangerous or overwhelmed?
So let me ask you this. What happened after you didn't make that court appearance? What'd you do?
Really nothing. I tried to survive out there. I was homeless. What Judge asked me is,
Okay.
why did you not contact the husband's office or the court? I didn't know what to do. Like I said, I was scared.
Okay, that's what you were talking about. Okay.
Like mental health proceedings and stuff like that.
Okay. So let me ask you this. How'd you come back into custody? What happened?
Somebody actually told the police where I was at, and they knew that I had a felony warrant. I guess that they came to the hotel, and I didn't know. I mean, that's how much I don't know. I opened the door. I was like, "Hi." They're like, "Hey." I'm like, "Hey." They're like, "Yeah, let's go." So I was like, "All right." Yeah.
You mean that's how you were talking to the police?
Yeah. We're okay. We're good. I mean, I don't, the police, they don't really bother me. They know that, they like me, but they don't. This sounds like an issue that this girl was off the medication. It's how much she's on her medication. It's how much she's been in custody. So I've been here 21 days, 21 additional days. She has no problem with the tether. It's necessary. She's hoping around consider at least. There's some fact that she's waiting, it's taking some responsibility. It's not resolved.
Any response from the people?
Your Honor, I don't have any objection to her being released. I'm not sure what the situation is now, where she's going to stay. But given that the location, I think, of the night incident was around the Banana Center, she mentioned she didn't have stable housing. So if there is a tether order, a GPS tracking tether might be appropriate.
Well, I'm not gonna put her on a tether. She has enough problems trying to find housing and put a roof over her head.
I mean, the Banana Center, I did have, I was there
And then you're gonna have to get back on the list to get, I know how it works.
Oh, I am, that's why I was so upset with myself. Like, I'm in the house, like the housing list, you know what I'm saying? I don't know how this all works. He knows how it works. And so he understands the difficulty you're gonna have trying to get back into someplace for the sake. I'm gonna stay here. That's not what he said. Oh, I'm terrified right now. I'm shaking.
You're what?
I said, I was terrified. I've never been this.
You're shaking right now?
No.
Why? Do I make you nervous?
No.
Why do I make you nervous?
It's the high pitch. Yeah.
Is that what it is?
It's the height for me, sir.
Oh, okay. I'm like such a kind and gentle soul. I don't know why.
This exchange is raw. There's sarcasm, there's tension, there's visible frustration. The judge is pushing back on attitude and tone. The defendant reacts emotionally. The courtroom dynamic shifts from procedural to personal in seconds. When a defendant appears dismissive or sarcastic, it can hurt credibility. Judges evaluate demeanor constantly. But here's the interesting part. Despite the tension, the prosecution does not object to her release. That's critical. The emotional friction didn't outweigh the legal factors. That tells you something. Even when personalities clash, the ruling must stand on legal footing.
Whoa, Emily, you didn't have to have that response. Wow. Alan, you could have stuck up for me. You could have. No. Wow. Everybody's just turned on me. All right. Miss Gregg, here's what I'm going to do. I'm going to reduce your bond. All right. In this case, I'm going to reinstate it back to what it was, to a $15,000 personal recognizance bond. Now, in doing that, Ms. Gregg, you got to make sure your next date is the 7th. You make sure you get there. You hear me?
Yes, sir. Yes, Your Honor.
Okay.
That face.
You didn't even think that would happen, did you?
That moment right there humanizes the entire proceeding. The judge acknowledges her surprise. That subtle exchange shows courtroom psychology, relief, gratitude, shock. But make no mistake, this is conditional grace. If she misses court again, that PR bond evaporates and custody resumes immediately. The contrast between cases today is striking. One defendant facing violent threat allegations gets reduced but still substantial cash bond and tether. Another with a missed court date walks out on recognizance. Context is everything. Charges matter. Behavior matters. Risk assessment matters.
Okay, you get out today. You're welcome. Take care of yourself. Wow. She did better than you.
Thank you, Judge.
Alan wasn't going to do anything. He just, see, Alan, you sorry. Wow.
Today's docket was a study in judicial balancing. We saw a case dismissed outright because the prosecution couldn't proceed, demonstrating how critical witness readiness is at the preliminary stage. We saw felony charges fall and misdemeanor stalking added, dramatically altering bond calculations. We witnessed explicit violent threats weighed against actual custody status, and we saw a defendant who missed court receive a second chance through a personal recognizance bond. Judge Simpson exercised discretion differently in each scenario, not emotionally but structurally. Bond is not punishment, it's risk management. Dismissals are not declarations of innocence. They are procedural outcomes, and every decision is grounded in probable cause, statutory codes, and predictive safety assessments. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.